last year was an extremely busy year for us, and uh, we tried to report that in the annual report that you all now have a copy of. Uh, the accomplishments that we did achieve, we've listed that in the annual report. And the goals that we've set out for this year, which is 2019-20, we've also put in there. In a nutshell, really our goals are to keep up with the increased file load that we're experiencing and to promote modernizing of the legislation. And I will go into a little more detail on each of those. First of all, on the file load, um, in since 2013, our file load has in fact doubled. And this last fiscal year, it was about 324 files, which there's a bar graph in the annual report that tries to reflect the progressive increase of those files. And in looking at the current calendar year that we're in, coming to the end of June, we have basically about 200 files. So we're projecting by year end that we're going to be somewhere around 400 files. That has implications for us. Number one, getting to the files as quickly as we should or want to. And as more come in, the pipeline sort of fills up, and it gets kind of difficult to get to the files as quickly as possible. And obviously, it creates a resource implication that once a year, when I have an opportunity to talk to the Board of Internal Economy, I will have to flag the pressures on us just processing the files we've got. The other objective is modernizing the legislation. And my term expires June 30th, but I've been appointed for another 5 years. And I was asked, so what exactly do you want to accomplish in the next 5 years? And thinking about it for a couple days and a couple weeks, the answer keeps coming back. I want to play a hand in promoting modernizing the legislation. Now, that takes a lot of work. It takes some work in this office, a large part of it by Diane and I, but it involves a whole bunch of people. And it involves persuading the Ministry of Justice to look at the legislation. It involves the government wanting to proceed with it, the opposition being supportive of it, and in due course, the Legislative Assembly passing it. And I've always viewed good legislation as that legislation that's passed unanimously in the House in the Legislative Assembly. So hopefully, in the end, we end up with one of the best legislative regimes in Canada. And now all those other provinces are updating theirs. The Northwest Territories has just passed amendments to their Bill 29, which brings their legislation up to date. The federal government has just given royal assent to Bill 58, which creates some improvements in their access and privacy legislation. The main thrust and the reason for a modernizing of the legislation is that there's been a radical shift in our world. We've really shifted from paper to databases, and those databases are all, not all, but many of them accessible through the internet. So we have gone from a file folder like this, which many of you will be familiar, to the same file being stored on this, a USB drive, or this, and an SD card that's even smaller, and there's even one smaller than this. We have gone and we've hauled this in here from a file cabinet like this that used to be full of files to a hard drive where it's all stored on here. Or the next step is we go up in greater consolidation. I want to go back to this file cabinet in order to get it here just to demonstrate the point. This is one of two left in our office, where once upon a time there were all kinds of them. And I expect if you looked across your offices or offices in government or the private sector, so many of these are gone. These are being used. And you know, the whole idea of a file room with banks of these has gone to it all being on a computer like this, or banks of computers. And I'm sure all of you have seen photos of a rack of computer servers serving a whole bunch of people. This server not even being in our location. In our case, all our data is stored over at the legislative building in a computer room that has banks of these. And then that moves on to server farms, and that moves on to the cloud. And the cloud, you don't even sometimes know where your data is stored in the world. So we've really had a radical change. Now, add to that access by the internet, and really, you know, that got started the legislation I'm mainly talking about was introduced in 1992, 93. The internet really got going with the introduction of Windows 95 and then Windows 98 in about 1995. And I still remember the Rolling Stone song, Start Me Up, and where the internet existed before that, but then we as citizens really started to use it. And then finally, if I can find it, and I'm sure all of you have yours in front of you, and some of you have probably been tweeting already about this morning, is the iPhone, the smartphone. 2007 was the first introduction by Apple of its iPhone, and of course competitors came out with their competitor model. And on this, not just making a phone call, as all of you know, sending a text, sending an email, taking a picture, or a video clip, which really all has kind of changed the world that we live in. So is it time to modernize? Is it time to look at our legislation in the context of a whole different platform as to where our data was stored? And these things are changing daily. I saw some emails this morning talking about the possibility that if you have a tracking device in your car, you can get a lower insurance rate. And now just think of the privacy and data collection issues of that. So we live in a digital world. It's a different world, and the consciousness surrounding privacy and access is greater. Headlines like Facebook and Cambridge Analytics, the federal government releasing a digital charter, all sort of add to the consciousness of where is our data, who has control of it, who safeguards it, who lets it out, when and where, and what do we consent to from time to time, or do we know what we've consented to? So in the annual report, we wanted to create a discussion. Do we have all the answers? No. Do we know where technology will be in two or 3 years? Probably not. But we do have some proposals of things that we think should change that relate to databases and internet, and we have no doubt there's more. And stakeholders or those providing input into the discussion will certainly come up with things that we haven't thought about. We're hopeful in that process that legislative amendments benefit citizens. They assist public bodies do the job and serve citizens in a timely manner, and also hope it assists our office give better service and make the rules clear as to what should be provided and what shouldn't be. So proposals are in the annual report. A few highlights that I just wanted to pick on were things like requiring express consent before using video or audio devices. Um, just letting people know that one's taking the pictures or the sound recording. Require notification in all cases and all three pieces of legislation when there's a breach and someone has been affected adversely, and also notifying our office. Example of a recent major breach is Desjardins in Quebec. About 2.9 million customers had a breach. And breaches can occur by someone from another country, or in this instance, as they're alleging, by someone inside the organization. So a need to be notified of that type of breach. To require trustees and government bodies to have audit functionality of their electronic systems. If you have hundreds or thousands of people accessing a database, you've got to have a way of seeing who's entering when and why. Giving the power for the commissioner of this office to comment on new technology. As I've said, we just don't know what will be here in 2 or 3 years. And when it happens, there's a need to talk about the privacy implications of that technology, or the access to information of that technology. We need to define the word publish. At one time, publish to me meant kind of publishing a book or publishing a newspaper. And now, those of you that may have been writing stories and posting them to the website have already published something. And what distinctions do we have to make on that sort of speed in terms of publishing? There's a provision in the existing act saying a government institution doesn't have to give you information if it's going to be published in 90 days. Well, that 90 days is kind of just not relevant anymore when you think of the website. And finally, a requirement that personal information and personal health information be stored in Canada. I think there's still generally a nervousness about storing information in the United States. I mean, we literally lose control. And certainly the major players have set up server farms in Canada now, where I think requiring our data about us to be stored in Canada and not have to worry about the Patriot Act or the Freedom Act or the next piece of legislation that Congress in the United States considers. Along the way, there's some things that are less directly linked to databases, but in a sense they are. One is we're recommending that a public body would have to appeal to court if they disagreed with a recommendation of our office. Basically saying our recommendations are binding unless you, the public body, goes to court. At the moment, it's sort of the reverse, that an applicant who's unhappy can go to court to have a judge consider the matter. And that costs each applicant things like $10,000 or $12,000 to do that. And I think that's an unfair burden, and it's time that this be switched around. The Northwest Territories has introduced legislation that contemplates something similar. The federal government in Bill 58 has given the Information Commissioner some ordering powers. So at the moment, BC, Alberta, Ontario, Quebec, PEI, Newfoundland, and now the Northwest Territories and the federal government all have stronger powers in their commissioner's office to require public bodies to act. Obviously and always giving them an appeal mechanism. We want to expand the meaning or scope of trustee to anyone that provides a healthcare service. There are corporate structures out there where we just shake our head in terms of, of whether they're covered by the Health Information Protection Act. And we just think if you provide a health service and you collect a whole bunch of health information, then you ought to comply with the requirements of the Act. Um, we're suggesting some amendments that would allow health professionals, students, residents in hospital, those in training to access personal information or personal health information for education purposes as approved and monitored by the trustee that they're working for. We also would propose expanding the scope of a government institution or a local authority. I mean, we have legislation coming along, and all of a sudden we discover that this particular agency hasn't been designated a government institution, and then it's necessary to request cabinet to do so. We think these entities, if they receive taxpayer dollars or supported by government or local authorities anyway, should automatically be covered by the Act. We're proposing that organizations who receive government grants, and if they collect personal information or personal health information as part of what they do, should be subject to Part 4 of the Freedom of Information Act. And what does that mean? Part 4 is labeled protection of privacy. So we're saying if you're an organization and you receive grants and you go about collecting my information, then you're obliged to protect it and keep it secure. It's probably in your database, and we want your database protected as best as it can. Similarly, government organizations who contract with government or local authorities, we recommend that they be subject to Part 4, protection of privacy. Again, if they're collecting your and my information under a contract for the government, then they should protect their databases. In a similar way, we're recommending that registered political parties have their databases protected by Part 4 of the Freedom of Information Act. Now, at the moment, an MLA's office is obliged to protect their information under Part 4 of the Act, and a minister's office is obliged to protect their information. So just adding registered political parties adds one more component to this obligation to protect whatever information you have in your database. Interesting enough, the Ontario Commissioner is releasing his annual report today, and he's making basically the same recommendation that political parties in Ontario have some obligations under their Freedom of Information legislation. We're making another recommendation that driver license information should be treated as personal information. We've ended up in a thing, and it may be as a result when this was drafted in 1992, that personal information did not include information under a license, and a driver's license is a license. So at the moment, that information held by SGI is not considered personal information. And I think there's some pretty important stuff about Diane and Kim and each of you in the SGI database where other people can say, I have access. I have a perfectly clean driving record, obviously, so there's not as much damaging information there about me. But for 1 million citizens in this province, I think there's some pretty sensitive information there. We're suggesting that there be a legislative review of this legislation every 5 years. And one reason for that is, the iPhone came about in 2007. And I bet you all of you now carry an iPhone or a competitor's smartphone. I don't have a clue what would happen in 5 years, and it's moving at that pace. And therefore, as new things come out, our legislation is going to get out of date. And we just need every 5 years to say, well, how much is changing in that 5 years? Let's bring our legislation up to date. So there could be a lot of change there's been a lot of change in the last 10 years. Will be much more change in the next 5 years. And we really need, as the digital world changes, to keep our legislation up to date. So with that, I'll close, and really pleased to answer any of your questions. There's a legislative cycle. The legislative meets in November. New legislation is usually introduced. It's left there for consideration of the public, and then it's passed in the springtime. So there's preliminary work that has to be done. Obviously, the Ministry of Justice probably would ask stakeholders to comment. There is election in 2020, and things sometimes slow down or stop when people are in election mode. So I'm kind of saying this is really probably a 2 or 3 year project before you would see something on the ground. But I thought it was really important to start talking about it now, because there's a lot of preliminary work to do, and then we sort of people work their way around an election, and then we have legislation that is introduced probably in the fall and then passed in the spring. So it's taking. It will take a little longer than I would normally like, but that's just the reality of where we are in the whole cycle of things. I think it's important for a few reasons. At the moment, we make a recommendation, and the head of the body that we make the recommendation to literally can choose to agree with it or not agree with it, or put in other words, ignore it. And then the citizen only has the choice of going to court, spending $10,000 or $15,000 to get a judge to look at it and make an order. We just think it would speed up the system. Citizens would get an answer from us. Hopefully our recommendations are mainly in the reasonable category, and public bodies would agree with it. And if they didn't, obviously you have to afford people the right to appeal. As I say, everybody has a boss. So if we recommend something and it's binding, we've got to provide people an opportunity to have a reconsideration of the issue. So it hopefully gives citizens quicker, faster action, takes away some delay, and forces us to scrutinize our recommendations more carefully, and forces public bodies to say, yeah, we can live with that. We can do this. Or maybe we'll have some interplay before the report comes out saying, well, you've recommended A, but if you modify it this way, we can do it. I think it would just make the system work a bit better. And it certainly is a trend across Canada. That's difficult to assess. At an objective level, we should always have a balanced approach, and so that one should never get too invested or too passionate about one's recommendations. On the other hand, when you work hard on something, and if we think our recommendations are reasonable, well, then you do develop some feelings about them. And I think at that point, when you carefully consider something and spend a lot of time kind of crafting it, and what we do in the process of making recommendations is you see, okay, what have the Saskatchewan courts said? What has the Supreme Court of Canada said? What have other provincial courts said? What have other provincial commissioners said on this topic or issue that's before us? So by the time the report comes out, we're feeling that we're being pretty reasonable, and we're kind of in step with the thinking in Canada. So, is there some disappointment? Yes. I think probably the citizens feel more disappointed because, well, it's their issue. But yeah, I think it comes with a degree of disappointment and frustration, and I think there's a real desire to uh, have a simple system and have it move more quickly and people be more responsive. It's hard to give you a specific example, but um, I recall one case, and I hope I get the facts right. Diane can correct them after if I stray too far factually. But we had a situation where a doctor's office was in a location, and I think there was a corporation in there, and this corporation rented from the landlord, but the landlord rented the photocopier and the computer that was in the premises. The doctors vacated it, and it ended up that the landlord was sitting with this photocopier with all kinds of information on the hard drive that basically that landlord was not a trustee. And so people, for tax reasons or liability reasons, structure themselves in such a way that all of a sudden they're not a trustee, but there was a health professional's office right there, and health professional office uses fax machines and computers and photocopiers, and sometimes those items get leased by a corporation that isn't quite a trustee. Another example, we have multidisciplinary situations where you have various health professionals in the same office, and and then they set up a corporation, and they're all part of this corporation, and we're here saying, well, is this person a trustee, or is that person a trustee? And the information is stored on a computer that's owned by the corporation. It just gets complicated, and it should not be complicated. If you're providing a health service in your facility, then you should be covered under the Health Information Act. Um, uh, and some of the obligations there would be, you need to protect this information. You need to secure it. You need to make sure that other people don't have access to it. And however you're set up, you should do that. Because if it has information about whether one has HIV or other communicable diseases, or one has cancer, or whatever the health issue might be, that should be protected however you structure yourself. We've certainly had some of it. I think there's a report on our website about watershed associations that are formed by municipalities. Let's see what else. Planning development boards that are set up under a different statute and aren't necessarily covered. Um, I don't think we've had an exact case on this, but we have a lot of local housing authorities who basically receive a lot of government funding in one way or another, and they're not necessarily covered, although the Saskatchewan Housing Authority is, but the local authorities are not necessarily covered. You think of a landlord, they can collect a lot of personal information about you, and 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 there's no protection, no ability for you to, in some instances, say, show me what you have about me on your file, or as importantly, if you're going to collect this about me, then you better protect it. And again, if you're collecting it and putting it on a database, have you made it secure so that people in Russia or wherever can't access it? So, yeah, there are some groups that are just beyond the edge that we'll continue to ask that they'll be there. But say next fall, the government sets up an XYZ agency. Um, in my mind, that agency should be automatically covered the minute the legislation comes into force, as opposed to Diane or I or somebody else in our office say, oh, by the way, the legislation was introduced and we have a new agency, and they're not a government institution. Or you might have the city of Regina setting up a corporation, and just the way they've set it up, it's not quite considered a local authority. We think there should be no question that those sort of boards and agencies or corporations are covered. I guess in an ideal world, I would like that 0% non-compliance. It goes back to, if we do the research and the analysis, if our recommendations are reasonable, which they should be, we should be heading towards zero compliance. But it is possible, and it occurs that sometimes we make 5 recommendations, and bodies will say, we're going to do 4, but not the 1. I'd rather they do 5, but keeping in mind that the head has the ability to implement the recommendations or not, I have to take that into consideration. I get more upset about those who choose not to respond to the citizen or to our office as to whether they will or won't comply. And I think at that point, they're starting to flaunt or ignore the legislation. And of course, being a lawyer, I believe in the rule of law, and that all of us should follow the law, but particularly any body created or funded by government is obliged to follow that law. So not responding to us is a flaunting of what the Legislative Assembly has said, here's how it's going to work. In last year's report, we labeled it Reducing the Risks, and most of it was about things that people can do. There's no silver bullet, and unfortunately, regrettably, probably breaches are going to always occur, but it takes a constant awareness on the part of an organization that their systems are vulnerable. I think if you talk to some IT experts, they would say there are attacks on our system every day. It's absolutely essential that agencies keep their software up to date. I recall it was a situation where the law firm in Panama got breached, and it was clear they hadn't kept their protective software up to date, and thus caused them an amazing, difficult, embarrassing problem. So keeping your software up to date is one thing. Guaranteed that as a worm or a virus or malware is found out and protection occurs, somebody in the world will be figuring out a way around it, and they'll do a modification of it, and attacks will be renewed. So there's kind of this constant cat and mouse. My dog's bored with the questions. No, he's not bored with he's bored with my answers. Sorry. A constant cat and mouse here, and that goes back to keeping your software up to date. The other thing, when you hear a security expert talk, they will say, yeah, you need to worry about the threats from outside, but you really need to worry about the threats from within. The accidental opening of an email that has embedded worms or malware in it that we all get, and the rule, like if you don't know where it's from, don't open it, really applies at home, at work, everywhere. So it almost takes constant education of people to be very cautious on their computers and resist that temptation to open things too quickly, to take that second sober thought before you do. Um, Snooping is an issue, uh, and when you have all this information there, some employee will be tempted at some point to snoop on the ex-girlfriend, the ex-husband, uh, an ex-friend, uh, maybe their mother. And most organizations have a policy: you do not look at your own health information or your relatives' information. And yet I think we see from time to time to time, people just get tempted by that. Uh, and the only way of countering that is mandatory annual training. Um, when a new employee comes in, the rules need to be read. Probably the person should sign a confidentiality agreement so that if they breach Snoop later on, they'll say, "You signed this, 6 months ago." Continuous annual training is probably the best thing you can do to just create the culture inside your organization that says there are some things you just shouldn't do, and here they are, and if you do, there will be consequences. Um, Desjardins is an example where I don't know the details, but they are saying in the news that an employee internally released 2 million names of clients and customers. Then I'll wait till investigations come out and more news, but sounds pretty intentional, sounds kind of malicious, sounds like it could ruin the reputation of a well-known organization in Canada. So you have to create a culture where everybody loves their employer and doesn't want to be malicious. Now that's a challenge. We all pay taxes, and we pay tax either user fees or municipal taxes or income taxes or on alcohol and marijuana, PST, GST. We all pay taxes. And I think in exchange for paying taxes, if we have government agencies spending our money collecting information, then we have a right to see some of that information. So it has always struck me that if the request results in fees that are less than $200, that should just be part of being a citizen of Saskatchewan and Canada. Now, fees do keep a bit of control on it because we've seen requests where people ask for 4,000 documents or a large number of documents. That does take a lot of work, and to have a little bit of discipline in the system is probably okay. Even just the photocopying costs of 4,000 pages is considerable. And if you're asking for 4,000 pages, could there be some communications with the citizen to say, okay, you're after this, this, and this. Can we give it to you in 500 pages or 800 pages? And if you ask for 4,000 pages, the fee will be this. If you ask for 500, the fee will be much less. But should there be a threshold under which we as a citizen, when we pay taxes, shouldn't have to pay? Yeah, I think it's, because we have to pick a number, I think it's 200. I think there is a rule of thumb in the system that at the moment, if the fee's under $100, you probably won't get a fee. But it isn't totally fleshed out and etched in stone that you won't get a fee. In the federal legislation, it looks like they have eliminated a lot of the access fees except an initial application fee of $25. So various people are approaching it differently, but as a taxpayer, you're entitled to something free. Under the Health Information Protection Act, we do have a number of private businesses that fall under HIPAA. And certainly your drugstores and your pharmacists fall under HIPAA. Well, cannabis dispensaries, are a dispensary, and some people are getting their information there because they have a medical certificate or whatever. It really, to some extent, depends on how much the dispensary is collecting. But it does strike us that if they're collecting information about your purchases of marijuana, then at least they have the obligation to safeguard that information, protect it. First of all, say, do we need this much information? Why are we collecting all this information? Isn't your Visa card just enough? So we thought it was important to put it in there to at least have a discussion about what they're collecting, what they're using, and how well are they safeguarding whatever they've collected.